day, everyone. My name is Tim Harty. I'm Mondac's Chief Executive. Welcome to today's Mondac webinar in association with Holland & Knight. We'll be discussing many of the commercial, operation, and compliance challenges confronted by airlines and aviation services providers. I'm joined by a brilliant panel from Holland & Knight to take us through today's discussion. Firstly, Anita Mosner is the co-chair of the Holland & Knight 150-member transportation and infrastructure industry sector group, and also leads its aviation team. Anita has devoted her 37 years of practice to aviation. Anita is an expert in the areas of aviation, antitrust, and international law, and handles a wide variety of commercial, regulatory, political, and operational challenges and disputes. With a background in consulting as well as law, Anita brings a highly practical and pragmatic approach to representation of airlines, UAS operators, airports, and other aviation-related businesses. Based in Washington, Anita deals regularly with regulators overseeing the airline business, such as the DOT, FAA, Transportation Security Administration, Bureau of Customs and Border Protection, as well as the Department of Justice and the Department of State. Anita is joined by Christopher Kelly. Christopher is the firm-wide section leader of Holland & Knight's 615 lawyer litigation section. Mr. Kelly defends airlines and manufacturers and their insurers in suits brought throughout the US, and he has significant experience in the defense of mass tort, toxic tort, and complex commercial claims. He has handled accidents due to fuel exhaustion, fuel starvation, passenger claims for emergency landings, airport construction contracts, and state attorney general investigations into the conduct of airlines. Before I hand over the panel to begin today's webinar, just one housekeeping item. You can submit questions to the panel by typing them into the questions toolbar on the right-hand side of your page. The panel endeavors to answer as many questions as possible during the session. Please do reach out to our panel after the webinar for additional information if your question hasn't been answered. It is now a big pleasure to hand you over to Anita and Christopher to begin today's webinar. Thank you.
Thank you, Tim, and greetings, everyone. It's a pleasure to be here, and thank you for attending. Can we go to the first slide? So by way of introduction, like every good litigation attorney, we like to lay a roadmap out for the next hour, so we're going to try to do that right here. The COVID-19 pandemic, that notation there needs no introduction. I think everybody knows what that has done to the aviation industry. But a few interesting points on that. One is J.D. Power found that overall airline customer satisfaction has dropped significantly from 2022 to 2023. That's going to be one of the themes as to what drives the regulatory circumstances and litigation risks that the airline industry faces in the near future. The dissatisfaction is largely due to staff shortage affecting the entire industry. Demand for aviation or air travel is sky high, no pun intended, and many airlines have not been able to rehire quickly enough. If yield management was the only metric airlines needed to be successful in the long term, this will be a banner year, operating at peak economic efficiency. From the customer perspective, however, that means planes are crowded, ticket prices are sky high, and flight availability is quite constrained. In addition, are the issues facing the airline industry, both domestic in the United States and international, is the decline in business travel. And we'll touch upon that as well. So the major trends that we're going to discuss are service disruptions triggered by shortage of staff and a slow rehiring process. I think many airlines at the time of COVID back in 2020 found it was easier to shut down than to restart. And those are issues that are present and are echoing and ricocheting through both regulatory risk and litigation risk in 2023. There's a changing regulatory approach to airline-consumer relationships, new rulemakings, which Anita will cover, and harder line on enforcement. The Biden administration's policy on consumer rights and competition is also getting refined and not necessarily in a positive way for the airline industry. And there are challenges to new and emerging business models. We'll talk a little bit about the pervasive impact of technology on regulatory and litigation risk, although that is very, very fast developing, and AI certainly will have a role in what comes in the coming months. So with that, I'm going to hand it over to Anita to discuss the scene setting and background for the regulatory situation.
Thank you, and good morning, afternoon, or evening, everybody, depending on where you are. We're just delighted that you're here and with us today. I'm going to set the stage a bit about what is happening in Washington and how the game has changed in terms of the view and oversight of aviation, basically regulation. One thing by way of background is under US law, the federal government has pervasive authority over airline businesses and commercial practices. So when Congress passed the Airline Deregulation Act, they said that the states will not enact any rate, route, or service pertaining to air travel, and essentially leaving DOT with the field, with the exception of contractual issues where customers can still go to court for breach of contract, but for breach of a DOT regulation, that authority rests right now exclusively with the Department of Transportation. At the moment, there is really heavy pressure by the White House and elsewhere on DOT to rein in and more tightly police air carrier behavior. Problems and dislocations caused by the pandemic, service losses, service disruptions, have basically made Congress, which always has interfered in the airline industry, even more attentive to what's happened in terms of service failure. At this point, too, what you find is consumer groups and state attorneys general have become very aggressive about giving consumers what they believe they're due. And under the regulatory regime, and they're expressing concern that consumers are not being made whole by air carriers, in part because DOT has authority to fine carriers, but they do not necessarily have the ability or power to order restitution to passengers in the event of a regulatory violation, although DOT looks at restitution as part of the process when they determine how to react to a regulatory violation. Next slide. One of the big things that we need to talk about, which sets almost the entire aeropolitical piece in perspective, is the fact that in July 21, the White House issued an executive order on competition. The order covered a really wide array of US businesses and agencies. But what it did is it called for much closer White House oversight of DOT enforcement of consumer rules and a closer review of industry consolidation. The order really does seek to reshape airline-consumer relationships. Essentially, in the order, the White House actually ordered DOT to engage in rulemaking in several consumer areas, and so the order actually specified that. They also have taken a look at what they perceive to be excessive power on the part of travel airlines and travel service providers, and have taken a look at airline alleged junk fees and charges. In fact, even the White House jumped in the most recent State of the Union message to attack basically airline and hotel practices. Next slide. Another theme that we're going to talk about is that there is really been a very, very subtle but perhaps very meaningful approach and change in the approach to alliances and airline cooperation. You know, historically, the Department of Transportation has been very friendly towards airline alliances. They've granted antitrust immunity to joint ventures between US and foreign airlines, and used that as a tool to encourage foreign trading partners to enter into open skies agreements with the United States. And you know, occasionally, the Department of Justice, which has authority over airline mergers, but not plenary authority over alliances, the agencies disagreed with each other. So in fact, let's say when British Airways and American Airlines applied for antitrust immunity for their JV, The Department of Justice weighed in on the docket and opposed the grant of ATI, and DOT approved it anyway, saying that there are important public interest reasons for doing so. The 2021 executive order expressly ordered DOT to consult with the Attorney General regarding means of enhancing effective coordination between the DOT and DOJ to ensure competition in air transportation. And so there is a White House Competition Council, and the White House has actually sent a new competition advocate over to DOT to oversee both enforcement rules and also the approach to industry structure and consolidation. And DOT now is taking a somewhat more cautious and slower approach to airline alliances. There are a few that it has disapproved or has conditioned very heavily, but when it has granted approvals, it now is looking both at the duration of the approvals and also the ability of third-party airlines to gain access to connecting traffic and the like. Next slide. Chris?
Yes, sorry, I was distracted for a second. Okay, so I think it's fair to say that regulation and litigation have a symbiotic relationship. Regulation spawns litigation, and litigation spawns regulation. The common denominator is a perceived deficiency that impacts negatively consumers or passengers. If you can recall, the tarmac delays of 15 years ago resulted in a PAX Bill of Rights that was commenced by an airline, not regulatory authorities. However, they have adopted it and taken to it with great vim and vigor, and those issues are going to continue to be resolved in the regulatory context as we see it in 2023. Discrimination claims from passengers led to additional regulatory guidance, and we can expect, I think, aggressive regulatory development and enforcement in the areas of data privacy, cybersecurity. These are all things that will be driven in tandem by both regulatory intervention and litigation to shape those regulations as well or interpret them. In line with the White House executive order on competition, as the slide suggests, and the new DOT rulemakings, there are 3 items that are going to be very much on the tip of people's tongues, I think, for the coming year. DOJ antitrust enforcement and oversight. It's already a matter of public record. The DOJ is materially more aggressive in looking at alliances, mergers, and the like, and that will continue, we believe, for the Biden administration and possibly beyond, depending on what happens in 2024. Consumer class actions challenging airline compliance with those DOT regulations and new rulemakings will be on the rise. They are a favored procedural device in part because it is generally a cleaner or it's fair or foul as to whether the regulation has been violated or not. And that's very, very attractive because both of the, not the simplicity, but the relative straight line for liability and the sheer numbers of passengers affected will make it an attractive area for increased class action activity. And then this is something that we highlighted many years ago, but is now coming to the fore, and that is, at least for publicly traded airlines, shareholder class actions alleging securities fraud arising from airline misrepresentations and operational deficiencies. The operational deficiencies are obviously factually idiosyncratic. The airline misrepresentations we are predicting will be an issue with respect to forward-looking statements made in SEC filings to induce investors to invest capital in airlines, and also many of the representations that were made in those public filings regarding ESG and environmental impact may very well come back to be the subject of litigation in the coming year or two. The pro-consumer theme likely to extend to court rulings is very obvious. There has been a number of cases now, or several cases, I should say, that are more passenger-friendly interpretation of the Montreal Convention terms. We'll talk about those in a second. The erosion of federal preemption as a defense under the Federal Aviation Act and Airline Deregulation Act is very real. Federal preemption probably had the high watermark of the empire immediately after 9/11. And from 2001 to 2008 was a very, very strong right arm for airlines with respect to fending off all sorts of claims. In 2008, the worm started to turn, I would say, and now it is, many courts are looking at ways to trim, limit, eliminate that particular defense, which again, as Anita mentioned, is tied to routes, rates, and services, are being interpreted now less expansively. Increased personal injury settlement value, we're seeing that aviation has become much safer. And as a result, those traditional matrices or matrices that would govern the types of hundreds, if not thousands, of claims, from the smallest to the most dramatic wrongful death claims, are being narrowed. But what we're seeing is that while there are fewer wrongful death claims in connection with commercial aviation being brought in the United States, the expansion of other claims, and including mental and emotional damages, is quite real. And we're seeing that that is driving up personal injury settlement values across the board. Anita?
All right. So we're going to turn now to some of the recent regulatory initiatives. And I want to, next slide, please. And what I would want to say right from the outset is that in determining what to talk about, we had to basically take a somewhat selective approach. It has been so busy from a regulatory standpoint that we really did have to winnow things down to a few recent initiatives that we want to highlight. The one thing I would start with, and which is really the overarching issue, is during the Trump administration, there was an enormous focus on narrowing the scope of regulatory authority and also limiting DOT discretion on enforcement. And as we'll see in a minute, the pendulum has swung very far in the opposite direction. And I would venture that we are seeing signs of potential re-regulation, but certainly a much more interventionist approach to both enforcement and interpretation of DOT rules. So in addition to taking a harder line towards alleged industry market power, we have a couple of new regulatory issues that have come up. One of which is the announced passenger refund NPRM, which came out last year, which was really basically implemented in the wake of pandemic inflicted service cancellations, DOT's ancillary service lead display NPRM, and there is also now a new potential NPRM about requiring airlines to make passengers whole, U.S. airlines to make passengers whole in the event a flight is canceled for reasons within the carrier's control. What we've also seen is a very interesting trend, even when the tools to implement new regs are not necessarily available to DOT. This department has been very quick to use its power to jawbone and use its publicity to try to shape industry behavior. So they now have an airline passenger service dashboard, which compares U.S. carrier services that will be provided in the event of a service disruption, and also a new Bill of Rights for disabled passengers, which of course creates no new duties on carriers, but merely puts the obligations out there and actually encourages much more active passenger engagement with the regulator. New slide. So the first thing we're going to talk about is the passenger refund notice of proposed rulemaking, which would require airlines to make refunds when passengers either cancel or significantly change their flights. The rule does allow carriers to offer passengers vouchers in lieu of a refund, but the refund must be offered first. But the devil in this case is in the details. The question is, cancellation is clear enough if a carrier cancels, but what is a significant change? For an international flight, DOT is saying that a change in arrival or departure of more than 6 hours earlier or later than originally scheduled is a major change. Changes to the departure or destination airports, for example, let's say if a flight was slated to go out of O'Hare and now is going out of Midway in Chicago, that is a major change. Changes in the itinerary, such as more connections or connecting points, or potentially a downgrade in service or significant downgrade in amenities in the travel experience. And it is that issue that has made, really created a lot of confusion and uncertainty. The rule also would require airlines to make passengers, give them non-refunding, non-expiring vouchers in the event a passenger chooses not to fly because of concerns or restrictions related to a serious communicable disease, or decide not to travel due to public health guidance or the advice of a medical professional. What this essentially does is largely obliterate the ability of airlines to sell non-refundable tickets, potentially, because of the ability to claim that you have a concern that would limit your ability to fly. So the rule as written triggers, new slide, triggers very significant concerns about fraudulent practices, and the ability to obtain a doctor's note and say, my patient was concerned about flying, please let them get a refund of their ticket, even if the passenger had nothing worse than a cold. DOT held a hearing to consider 3 factual issues, and the hearing was held this March, which is whether consumers can make reasonable self-determinations about their risk of contracting a serious communicable disease, whether the documentation is sufficient to prevent fraud, and how to determine whether a downgrade of amenities or travel experiences qualifies as a significant change in flight itinerary. So I think the issue there is an interesting one. It's, on the one hand, for a passenger with a disability, the change, let's say, from a wide body to a narrow body aircraft may mean that a lavatory is accessible or not accessible. And I think everyone would agree that that is a real change that should allow the person with the disabilities to change or alter their flight. But what happens if there is an unavailability of IFEs, or there are certain amenities that are provided that are not available on a particular flight due to an operational reason? DOT held the hearing in part because they are concerned about a judicial challenge to this regulation and a determination of really whether their actions will be viewed as grounded in fact and not arbitrary and capricious. At this point, we're expecting an issuance of final rule. The comments are in, the period is closed, but the timing of that is uncertain. Next slide. In October of last year, DOT came out with a proposed regulation involving the transparency of ancillary service fees. And this NPRM essentially is a resurrection of a rule that was proposed in the mid-teens and was then basically abandoned by the Trump administration. And essentially what it would do is determine that certain types of fees are critical to consumer decision-making, and that they should basically be available across, not only on carrier websites, but available across a range of sales channels, whether or not the carrier has sold a ticket directly. So they covered in the regulation are baggage fees, change and cancellation fees, and seat assignment policies and fees. The rule would prescribe the disclosure of these fees on carrier websites whenever fare and schedule information is provided in response to an itinerary search, and would require air carriers to share their free information with all ticket agents that sell that carrier's tickets in a manner that is usable, accessible, and in the case of seating fees and family seating, transactable in real time. And DOT would actually put this on both, consumer websites and also desktop and mobile websites. The issue that has come up is it's one thing for a carrier that is selling through their own sales domain to ensure that information is fresh and accurate. What this rule doesn't talk about is who pays for data, the transfer of data from airlines, let's say, to GDSs and OTAs. Who is responsible if the information is not kept up to date, if the information is changed. And there are larger issues. DOT had a hearing on the NPRM where both the GDS providers, travel agents, and carriers all question both the need for the rule and whether technologically compliance is going to be feasible. And that is, I think, a very, very material concern. At this point, the comment period is closed on the regulation, But I personally will put my foot on a banana peel and say I have some questions about whether or not this rule will go to final in its current form, given the universal concern on the part of the companies that actually provide the digital backbone to comply with this. They're concerned about their ability to actually comply with the regulations and make things like family seating transactions transactable across a wide range of various travel domains. Next slide. We talked briefly about the fact that DOT has started to put out information on a website about the services that carriers provide, U.S. carriers provide in the event of a service disruption. DOT is now considering a rulemaking that would require airlines to provide things like hotel accommodation and meals and other benefits in the event a flight is canceled for a reason within the carrier's control. The airlines also would be obligated to provide timely customer services during and after periods of widespread service irregularities. And they also would try to define what's a controllable cancellation or delay. Although we don't know a date yet for this proposal, my head is pounding already, because I think the question is, will DOT consider things like airline staff shortage when determining whether or not there is timely customer service, and also the effect of ATC shutdowns on the entire, air transportation network? What we have found is that carriers often have to position their crews in order to handle flights. And although, let's say, a lack of crew might be arguably a carrier control delay, an ATC system delay may have actually directly caused the lack of availability of crew. So I don't know how DOT is going to thread the needle in this regulation, and I'm somewhat concerned about where they're going in this.
So, Anita, I'd like to make a comment on that in that respect as well. On the operational side of airlines, this is a particular nightmare. If a flight is delayed for whatever reason, you do not want to be debating in the lobby of the airport with passengers whether it was the airline's responsibility or not. Many of these flights, because of the comprehensive route system we have in the United States, many of these flights are to, I wouldn't call them remote locations, but locations where these types of services are not available 24 hours a day, 7 days a week. We've heard the horror stories from all of our airline clients about delays that have either passengers at 10 p.m., 11 p.m. in smaller markets. So I think that this is it's a nightmare, and it will be a beacon for litigation for years to come, depending on how I'm not sure it depends how the regulators interpret it. I think it is so open-ended and so problematic from an operational side that it's going to be litigated for years.
Thanks, Chris. And that was my exact thought. I think we're in violent agreement on that one. Next slide, enforcement updates. So at this point, what we have seen is DOT is now going for shock and awe in its approach to regulatory enforcement. In the passenger refund cases, we have seen 9 orders thus far, with a range in penalties from $175,000 to $4.5 million for failure to make timely refunds to passengers. But I think the story is not only here, which is obviously the topic of refunds has been, a political, basically a political piñata for the carriers, but I think that DOT is also seizing on other issues like tarmac delays and seeking 7-figure penalties for those. And that, I think, is the story that people are not focusing on. The other thing that I think it's important to bear in mind is that DOT is trying to very dramatically expand its enforcement staff. I know that there are probably at least 40 or 50 people there now, but I think that they are trying to get greater numbers in order to investigate alleged infractions more thoroughly. The other thing that I think is also worthy of concern on the part of airlines is that DOT is looking for errors and infractions in real time. And in the case of overflights of conflict zones, which I'll talk about later, what you find is that DOT is actually looking at FlightAware and looking at things like the Baghdad FIR and Ukraine FIRs, and actually looking whether any flight with the U.S. carrier's code is transversing that region. The other thing, too, is that after a major weather event, they will be looking for things like carriers having tarmac delays and actually looking at FAA records to determine whether or not they have potential regulatory violations. The other thing that I thought I wanted to talk about before I close is the fact that DOT reportedly is weighing enforcement actions against carriers that have, let's say, experienced a service meltdown over a period of either really adverse weather or some other type of external cause. And they are questioning about whether or not they will penalize carriers for basically publishing deceptive flight schedules if, let's say, a carrier knew or should have known that they were unable to operate a flight. Now, I don't think that this has reached any sort of formal stage, but I think it's a point of concern that keeps me up at night. So that is the end of the regulatory section. I'm going to hand the floor over now to Chris.
Thanks, Anita. Let's go to the first slide. So Anita talked a little bit about the fines that were being assessed, and we're now about to enter. This is, if we were playing poker, the table stakes are about to get a lot higher, because we're going to talk about cases where other agencies in a different context, but nonetheless with aviation players, in this case Boeing, have taken a rather different view towards the amount of monetary sanctions and penalties. So the first slide here deals with the FCC settlement with Boeing, related to 737 MAX. There was the FCC charged Boeing and the CEO of Boeing at the time with misrepresentations and misleading public statements regarding the 737 MAX aircraft in the wake of the two fatal accidents. The FCC orders found that Boeing and its CEO negligently violated the anti-fraud provisions of federal securities laws. And as a result, there was a consent order entered in between Boeing and its CEO with the FCC. Boeing paid $200 million, and the CEO paid $1 million, respectively. There's also a fair fund established for harmed investors under the Sarbanes-Oxley Act. That turns out to have been a relatively modest issue for Boeing, because they also entered into a deferred prosecution action, a deferred prosecution agreement with the United States and the DOJ. And the DOJ had considerably more teeth, because those were they were possible criminal penalties and criminal sanctions against the company. So in 2021, DOJ and Boeing struck a deferred prosecution agreement, which resolved a criminal charge that Boeing had conspired to defraud the FAA regarding changes to flight stabilizing software in the 737 MAX aircraft. Under the deferred prosecution agreement, Boeing obtained immunity from criminal prosecution and agreed to establish a $500 million fund to compensate families of those who died. They also agreed to pay a nearly $244 million fine and establish a $1.77 billion fund in compensation to airline customers. Passenger families challenged the DPA, and the court previously held that passengers qualify as crime victims under the Crime Victims' Rights Act, and the DOJ had not complied with its legal obligations by virtue of the fact that it negotiated the deferred prosecution agreement with Boeing behind closed doors. It ordered a public arraignment of Boeing, the court did, where victims' families were permitted to speak, and they did. The families requested court supervision of the deferred prosecution agreement, but ultimately the court deferred or declined to exercise that, saying that this was new ground and that this was a DOJ issue that they had negotiated, and the court ruled that it did not have the legal authority to withhold approval of the deferred prosecution agreement's substantive terms, or the DOJ's own internal decision to negotiate the DPA in private. Nor did the court find that it had the authority to supervise or substantively review and reject the deferred prosecution agreement. That case is at presently up to the Fifth Circuit for a writ of mandamus. We'll stay tuned on that, but I think the important point there is, in the course of the last 15 minutes, we've gone from $1 million penalty that Anita was talking about, and we're talking about billions of dollars in connection with a sliding scale of the potential for criminal prosecution. So the stakes are getting much higher, depending on obviously the agency or the identity of the agency bringing the enforcement action. But to me, it's quite a stark picture as to the sliding scale of what the federal agencies are doing now, or what they deem to be, quote, fair, end quote, or just compensation with respect to various activities, at least at Boeing. Next slide, please. So there's an uptick in consumer class actions, as we predicted, or as we noted at the beginning of the presentation. Southwest Airlines operational meltdown is of relatively recent vintage. It took less than a month for the first class actions to be filed there. The severe winter storms forced a number of airlines to cancel thousands of flights in the days before Christmas. Many of the domestic airlines in the United States escaped the full wrath of passengers who were traveling at a critical time by canceling hard and canceling early. They took down their schedules in the 10 days before Christmas quite aggressively. Southwest did not do so, and as a result, it took over a week to reroute passengers due to operational systems that were, frankly, likely outdated, but we'll have to see how courts decide that. But it left the operational systems were overwhelmed. They expected loss to Southwest, as reported in its SEC filings, are $825 million. The DOT intervened and instructed Southwest to process refund requests within 7 days of pay by credit card and 20 days for other payment methods, and to reimburse travelers for alternate flights, rental cars, hotels, and meals, and respond to consumer complaints within 60 days. With respect to the reimbursement to travelers, if you go back, if you can reflect back to what Anita was talking about, this is the core of the regulations that are now being reviewed and possibly implemented with respect to how do you compensate passengers under circumstances like this. The hypothetical, and it's not really a hypothetical, but the likely scenario is that it was reasonable to anticipate that with the systems in place, that the airline could not respond effectively and efficiently to this type of cascading meltdown that would that occurred in December, and that is the point, I think, of the regulations that are being considered, is to think ahead and develop these plans ahead of time, but they should not be unanticipated by airlines. The first lawsuit is, as I said, was filed within days of these events, as you would expect. Captiville versus Southwest Airlines, pending in Louisiana, is a purported class action filed alleging breach of contract for failure to provide those refunds, including timely refunds for tickets purchased with credit cards. Southwest filed a motion to dismiss for failure to state a claim and ADA preemption. It is sub judice. It's not decided yet, and we'll need to keep a close eye on that to see where it goes. The COVID-19.
Can I quick jump in really quickly on an issue? The one thing I think is of interest here is the winter meltdowns didn't only affect airlines; it affected all forms of transportation. And clearly, airlines live in a bubble and are singled out, I think, for extreme attention. But I think the one thing that goes into the whole question about advocacy is, there's part of a larger transportation writ large, all of which got disrupted. And it is really, I think, somewhat fascinating to see the level of overreach and extension of, federal regulatory hand into this particular type of scenario, when people traveling by train, by bus, by automobile may have been as affected. So I'll get off my soapbox. Chris, carry on with my apologies.
No, it's an interesting point, Anita, and I think that goes to, I'll defend my airline history, my airline past, and my airline clients. I think that much of the public does not understand how sprawling an operation it is to operate that single flight. And in fact, if you were to, like a Hollywood movie, run credits at the end of the flight, there'd be thousands of names necessary to make that single flight possible. So I think that that and a voracious press which makes headlines out of any kind of airline failure, it seems, creates a downward cycle, I think, for airlines that put them under a different public scrutiny and different public pressure. But I agree with you that that's exactly right, that the December event was crossed many sectors, and it was, but it was the airlines, and it was really sort of the airlines which did not have, I think, that resilience. They were not at full strength because of the hiring issues that we discussed earlier, staff shortages and other things, only accelerated or amplified, exacerbated, whatever you want to say, those particular negative events in December. I was going to talk about the COVID-19 airfare refund class actions. We're going to round up the usual suspects, so to speak. There are many of these cases that were brought, and they began back in as soon as 2020. Every airline is somewhat factually idiosyncratic to the extent that they have varying contracts of carriage, and the interpretation of those contracts of carriage, at least in the early days of these cases, were key in determining whether airline breached the contract. Many cases were found under the ADA to be preempted for the state law claims other than that breach of contract claim. Several airlines obtained early dismissals where the named plaintiffs failed to state a breach of contract claim, or the contract of carriage, interestingly enough, contained class action waivers. Class action waivers, we don't have all day, so I'll just offer this opinion, and that is that class action waivers are very common in all sorts of contracts, and what is happening is that the bet, I suppose, was always that a class action waiver was a plus for the service provider or the vendor, but we now are seeing cases, and we are now seeing technology applied to those cases that allow that contract that class action waiver to be circumvented by the joinder of hundreds, if not thousands, if not tens of thousands of smaller claims into an effective mass action, not a class action, a mass action. And that is a function of technology. That is a function of the investment in being able to take claims and analyze them, and simplified claim forms and things that plaintiffs' firms are using. And we are seeing that in all sorts of contexts where the defendant will go to court and say there's a class action, they can't bring a class action because they waived it, and then these plaintiffs and their law firms are pivoting to unite all these claims with improved technology and bring 3, 4, 5, 600,000, tens of thousands of claims at least in the arbitration context because they waived the right to a class action. Anyway, a number of airlines reached settlements after motions to dismiss were denied and the court allowed repleading, and others are still litigating class certification. The early line on this is that the COVID-19 airfare refund class actions will probably not be completed through courts of appeals and other decisions, probably through 2025 or maybe even 2026. Next slide, please. So I promised a little discussion of shareholder class actions. Here's 3 of them. The Boeing Company aircraft securities litigation is in discovery. Again, that all arises out of the 737 MAX. The College Retirement Equities Fund versus Boeing is at this point a 2022 case. There's a pending motion to dismiss, and Boeing is seeking dismissal of investment fund securities fraud lawsuit, which alleges that Boeing downplayed and misrepresented the 737 MAX safety flaws after 2 deadly crashes. A little bit unclear at this point. Remember, the Fifth Circuit has the deferred prosecution agreement pending. This all has to be worked through as to what the practical impact of these various claims, settlements, proposed buckets of money that are being set aside, as to where they fit, but that remains a subject of further court review and court decisions. Terraganesian versus Southwest Airlines is again tied to the December last year meltdown, And it's a lawsuit that claims operational disruptions were avoidable and resulted from managerial negligence, which jeopardized the airline's operational stability and threatened shareholders' investments. A case management order is about to be entered there. So the case is in its very early stages. It is going to be very, very difficult, or I predict it'll be very difficult for shareholders outside of a very limited window who bought and sold in a certain period of time or sold in a certain period of time to prove damages. It's going to be a tough case for the plaintiffs. Next slide, please. The pro-passenger case developments. The Montreal Convention, there's a couple of recent rulings that reflect the pro-passenger interpretation to Article 17's accident requirement and related to the recovery of emotional distress damages. This has been the subject of years and years of jurisprudence. Most of it has been pretty consistent, that in order to collect damages under Article 17 for emotional injuries, it had to be related to a bodily injury. The bodily injury had to directly relate to the emotional and mental harms alleged. Typical cases involved harm of a type of scars, facial injuries, things like that, where there was an attendant emotional component which says, I am not what I was, I'm somehow diminished. Plaintiffs were allowed to try to make that claim that tied that to the actual bodily injury. In Doe versus Etihad Airways, that's noted there, there was a little bit of a wrinkle where the court invoked a new test and suggested that an air carrier is liable for any mental injuries so long as they are traceable to the accident, not necessarily the injury, but to the accident, regardless of whether they are caused directly by the bodily injury. This has a chance to open up the door to many, many other claims, lower the standard for damages that are collectible in that context, and is, again, can only be interpreted, I think, correctly as a pro-passenger ruling. It is expanding passenger remedies from what had historically been the Montreal Convention's limitations on the definition of an accident. Next slide, please. So, interestingly enough, the courts are wrestling with this. The Bandari rejected Doe's broad holding and confirmed that recovery for mental injury still must be caused by physical injury. And then Oshana versus Aer Lingus out of the Northern District of Illinois said that essentially adopted Doe, where it agreed that recovery for emotional distress does not need to be caused by the bodily injury. Stay tuned. This is going to go through various circuit courts. And if passed as prologue, there may very well be a split in circuits that goes to the Supreme Court probably in 4 or 5 years. On the European side, the Lauda motion case is one where the court there found the drafters of the Montreal Convention did not intend to exclude psychological injuries and bodily injury requirement, despite recognizing that they rejected, the drafters, every proposal to add it. That decision contradicts decades of internationally recognized case law, and we'll have to see how that develops as well. Next slide, please. Code sharing. Actually, Anita, I think this
that's me. Yep. So we're nearing the end of our presentation, and I think one of the things that we wanted, and Chris will jump in on these topics, are what are the issues that we're watching? And I think that there are several. The first thing, I'm going to jump to the bottom of our slide, is the fact that here in Washington, there's an ongoing debate about, the new FAA reauthorization bill, which is under consideration. And we're expecting to see a lot of new provisions or attempts to put in new provisions involving passenger rights and expanded duties to passengers with disabilities. We're going to be seeing fights about access to airports. I know right now there is a plan to expand the number of slots at Reagan National Airport in Washington, and they're skirmishing about who would be entitled to them and whether there should be new slots created. I think we're going to continue to see fights about airline alliances and consolidation. I think, while there's a hiatus at the moment and things have been a little bit quieter at the Department of Transportation on ATI applications, I think that this is still going to be a focus point of controversy. One thing that I hadn't mentioned before is a fight over scheduled charter operations. A number of carriers and labor unions have since taken aim at basically applications of carriers to provide public charters operated to and from FBO facilities. And these are operated as Part 135 commuter operations, and they don't have normal TSA screening. The various labor unions and several carriers have said called foul on this, saying that this is really a de facto scheduled service and should be subject to the same operating regulations, both under the FAA Part 121, but also under the same TSA standards. And we've had one carrier that have basically applied for traffic rights last summer and still has not received its certification, in part because of ongoing fighting in the public docket about their service plans. The other issue I wanted to quickly mention is fights over conflict zones. And what I mentioned before is that under US rules, although FAA no times apply only by their terms to US carriers, when a foreign carrier carries a US airline code on its flight, the FAA no tabs apply to the foreign carrier as well. And what we saw recently is for Virgin Atlantic and Delta, Virgin got penalized over $1 million for basically overflying the Baghdad FIR while operating, between the UK and India. And I think it's interesting because of the reach of the US jurisdiction, which can really cover, a flight operated wholly between foreign points. But it is a point of concern, and it is something that the FAA is looking at very closely, and the DOT is looking at very closely and ramping up their enforcement actions. So before we close, Chris, are there things that you would like to add?
No, I think that the general theme, though, is that from an airline's perspective is that the expansion of pro-passenger court decisions is in full swing. I don't know what it will take to have the pendulum swing the other way, but for right now, I think airlines are need to improve, obviously, their operational efficiency. I don't want to state the obvious, but I think that a little bit of foresight in terms of trying to limit the possibility of potential claims is probably a good idea. I think that there's probably for the airline that does not address that, there will be a regulatory intervention on almost a pattern and practice basis if things aren't fixed. And that will spawn a whole set of lawsuits as well, as we see. There's a certain game plan to this, or there's a certain almost liturgical calendar feel to it, which is the regulators say ABC, airlines either meet it or don't. When they don't meet it, there are lawsuits that invoke the protection of the federal rules or laws that are passed to protect passengers. I think that's going to continue for a while. So anyway, I think that forewarned is forearmed, and I think trying to think out, particularly in those points of operational problems in the past, I think are a good thing to do.
All right.
Particularly seasonal issues. Winter and summer seems to be the high water marks, and most airlines, I think, are well prepared for that, or should be.
All right, so I think we're going to turn to questions now, and if that's okay with our organized conduct, I assume that's okay.
That is absolutely okay. Thank you very much, Anita and Christopher. That was excellent. Okay, so in the remaining time, we've had a couple of questions through. If you'd like to ask one, please use your panel to put that question to the organizers. So let's go to question one. What is the one piece of advice you would give to foreign airlines serving the US? And I will direct that to Anita.
I would say the single most important thing, but perhaps is the least specific thing, is looking at corporate hygiene and looking at your systems. I think the challenge that has happened during the pandemic is that people have lost staff and headcount, and that a lot of compliance procedures have largely need to be dusted off and reinvigorated. So that could be looking at something like re-educating your airport ground staff about tarmac delay requirements. It could be looking at your emergency contact list on file with the DOT and the NTSB to ensure that it's current. It could be ensuring that your training for, which is mandatory for passengers with disabilities, is up to date. And then it's a question too of ensuring that you have, new responsible people to the extent to which roles and names have changed.
Right. Thank you, Anita. Let me take another one here. How can airlines business continuity management teams best prepare for some of the risks you've discussed on today's webinar?
Chris, would you like to take a stab at that, or would you like me to?
I think I can start with it's never a poor investment to do something, because even if it does not work, it will provide you the defense. The worst position an airline can be is it was reasonably anticipated or should have been reasonably anticipated, and the airline did nothing. So any steps are better than no steps in terms of a prospective defense down the road. You want those steps to be effective, again, within the economic parameters of what makes sense. So some of the rules that the DOT has, it sounds like a little bit like a Christmas wish list, but it's very difficult, as I mentioned, for airlines who are flying complicated routes or 1,000 or 1,200, 1,500, 2,000 flights a day to make sure that they have hotel coverage and transportation coverage in some of the smaller markets to which they may fly. So I think that having a plan in place would be helpful. I think that it would, again, it has to be economically realistic, and that's where the clash is going to be, I think, with the agencies. But again, under any circumstance, having a plan is better than no plan. So I think that if you have something in place, and I think most airlines do now, and they're working on that, they're anticipating that these rules will come into effect. They'll fight them, they'll object to them, but that something's going to change in that respect. So you cannot get on this too early, I would say, in terms of a plan. Anita?
No, I agree with that. I wouldn't change much to that answer at all or amend it much. I think it's really good.
Thank you, Chris. Okay, time for one more question. I think I'll put this one to you, Anita. Are there significant international aviation issues facing the industry?
Well, I think the whole issue about Russia overflights has basically spawned concerns and disputes ranging from transactions involving Russian lessors and Russian operators being, banned from multiple jurisdictions. There is a question, of course, that the U.S. and other international airlines no longer are using Russian airspace. And in the United States, there's an ongoing issue about there are U.S. carriers that can no longer overfly Russia while en route to Asia, and also are basically even one en route to the subcontinent having to take longer routings. But there are airlines from other jurisdictions that aren't subject to that. So right now there's a large debate going on in Washington about whether or not the federal government should take any action to put its thumb on the scale and try to level competitive playing field. Of course, the arguments being made are being couched in safety terms, and we can talk about those. And of course, I think the U.S. is concerned legitimately about the safety of its citizens who might be on a plane overflying Russia. But there is also another component to this as well. But I would say that, Russia-related aviation issues are on everybody's agenda and radar screen.
Thank you, Anita. There are at least 3 more questions that I've seen. We don't have time to answer those, but we'll make sure that we hand those over to the panelists. And we want to say a huge thank you to our speakers, Anita and Chris, today. On behalf of Mondak and Holland & Knight, thank you for joining us and have a great day. Thank you.
Thank you.
Thank you.